So today we're talking about wiretapping because especially the federal wiretapping laws cover a lot of different stuff. Really only talking specifically about recording conversations. So this has been relevant because one troll at least has talked about Chile recording Todd Lyons' conversations, how it's illegal wiretapping. And then there's the whole Turtle Boy meeting up with Irish Demon. And supposedly there's a recording of the conversation. And I think Irish is saying that he didn't record this conversation because he knows it's a two-party state. But he's claiming maybe that a third party recorded them. And it's okay because it was in public. So we'll probably dig into that. So the federal wiretapping law is mostly in Title 18, Chapter 119. So the federal wiretapping law basically sets a minimum protection for all 50 states. And then the states can be more protective if they choose. So the federal wiretapping law is basically what they call a one-party law, where you only need one person's consent that's in the conversation to record that conversation, as opposed to a two-party or really an all-party where everyone in the conversation needs to give permission. So of the 50 states, 38 are still one-party states. Then, that would mean 12 of them have decided to add additional laws requiring consent of all parties, although those 38 states may have also made additional laws for additional protections, but left it requiring only one party's consent. So how the federal wiretapping laws really got started was because of government's overreach in recording conversations to use it as evidence to violate people's Fourth Amendments. So in 1968, the Omnibus Crime Control and Safe Streets Act, which is also known as the Wiretap Act, was passed and basically made it that if the government recorded you without court order, subpoena, warrant, or whatever, that the evidence couldn't be used in trial, in criminal trial against you. Well, I guess it can't be used in a civil trial either, but the thing is that, I mean, it made it illegal for them to do it, but also doesn't defeat their qualified immunity. So in reality, the police or federal agents can record your conversations all day long. They just won't be able to use it in the evidence in court. So they can definitely use it to build a case, right? They're not supposed to. It's illegal, but their qualified immunity would protect them. And then go ahead and get the warrant when they actually want to use something as evidence. So the laws could be better. And then in 1986, we amended that because at the time those laws really only covered recording of telephone conversations. So in 1986, we realized we needed to protect more conversations that happened electronically, like cell phone conversations, wireless phones, even email was added. And then, of course, the Patriot Act and all of its updates from 2001 and 2011 were also added. So this isn't the actual language of the statute. I've simplified it, but basically the federal wiretapping law says it's illegal to eavesdrop on any wire, oral, or electronic communication, including email, and then record any wire, oral, electronic communication, and it's done remotely or on the premises of a business engaged in interstate or foreign commerce. So it's interesting. So one says it's illegal to eavesdrop, and then the other one says it's illegal to record remotely. So does that mean you can record locally then? So that is no. So when they wrote this, they meant for these two things to overlap. So if you're recording, recording is also eavesdropping. So no. And then it's also illegal to disclose or use the contents of any communication that was gathered illegally. And then it's also illegal to attempt or cause any of the above. So that's relevant because if you ask someone to do it for you, right? So you caused it to happen. So you can still you are still personally liable even though you're not the one that did it. Which is the main reason why they add that type of language in there. I don't know if anyone's actually been arrested for the attempted. So there are some statutory exceptions. Number one, the party of the conversation. So you are a party of the conversation, or the conversation is happening on your phone or device. So in federal law, all of this is under the wiretap law, but a lot of states, when they break this down, if you're not a party of the conversation and you're recording it, they call that wiretapping. And then to record a conversation that you're a party of is usually just a privacy law. So one interesting thing about this first one, you're a party of the conversation, or they're using your phone or device. It's that's only if you're a government, or if you're doing it under the color of law. If you're not doing it under the color of law, not only does you have to be a party of the conversation, or they're using your phone or device, but you also can't be doing it for the purpose of a crime or tortious act separate from the recording. So if you're doing it on the color of law, it's weird. You can do it for the purpose of a crime or tortious act, is what they're saying. I mean, they're assuming that if you're doing it on the color of law, that's not your intent, but we know better. And because a private party can't do it for the purpose of a crime or a tortious act, even if everyone consents to the recording, if you're recording it for the purpose of a crime or tortious act, you are not allowed to record it. So I think that's the biggest reason why they added that in there, so that but it really should have applied to the people of the doing it under the color of law as well. Like, even if you have everyone's consent, you should be able to record it for the purpose of a crime or tortious act. The other interesting thing is if you're doing it under the color of law, you don't ever need to obey state statutes. It's always the federal one-party rules is always going to apply. So basically what this means is, informants will always have permission because they're, if they're wearing what's that called, a wire, right? And they have a conversation with you, they're obviously consenting to the recording because they're the one recording it. So they have their one-party consent. All right, so we deviate a lot on that one. So basically, some statutory exceptions are you're a party to the conversation, or they're using your phone or device. So you can record all conversations on your phone, even if other people are using it. And that's just established in case law. And then if you unintentionally do it, this law doesn't apply to you. If you have a court order, doesn't apply. I mean, we kind of covered that already. Part of operating a communication service, if it's done under that. So if you work for, AT&T and provide phone service, and someone reports problems with their line, you can listen on that line to test it. For an example, there's lots of other examples. And then because of the Patriot Act stuff and similar laws that have passed, if there's no U.S. citizens in the conversation, this doesn't necessarily apply. If a terrorist is one of the parties, this doesn't necessarily apply. And then also an exception is if the electronic communication is generally available to the public. For example, radio broadcast or content on a website. And then, or streaming on YouTube. And then also an exception is if no party exhibits expectation of privacy in circumstances justifying expectation. So sometimes, even without everyone's consent, if no party exhibits the expectation of privacy, and even if they do exhibit expectation of privacy, if the circumstances don't justify that expectation, you could record them. And so this specifically is sometimes recording in public. So one party might have an expectation of privacy, but under those circumstances, maybe they don't. If you are having a conversation in an interview room in the police station, you might wish to have a private conversation and even express that, but you don't have any reasonable expectation that would justify that expectation, unless you're talking to an attorney. So if you're talking to an attorney, they are supposed to turn off recording. So these laws, the federal laws, also offer a private cause of action, which is cool because not a lot of federal crimes do have this. So instead of, or if you can't get the feds to prosecute, which is likely the case because they're busy, you can still sue. And if it's that person's first offense, there's an automatic statutory award of $500. And then that same person, even if it's a different person suing them, if it's their second offense, that plaintiff would get $1,000. And then after that, it's $10,000. So you don't want to be caught doing this more than once. But so one interesting thing is that there's no private cause of action against third parties. So if you hire a PI to bug someone, and then someone sues, they can't sue that PI. They can only sue the person that hired the PI. Right. So I mentioned some case law in the previous example, but here's some other interesting ones. So it's okay for media to publish illegally recorded conversations of public concern. So that's not saying it's okay for the media to illegally record, but if they obtain an illegally recorded conversation, if the conversation is of public concern, then they can share that. And this is because, in general, some First Amendment guarantees are still offered, or under this criminal law, obviously. And then it's okay if at the time of recording, it's not done with a device for separate criminal or tortious intent. So what I mean by that is that rule where a private person, right, not doing it under the color of law, can record it as long as they're not doing it for a separate criminal or tortious event. So they could use that recording for a criminal or tortious event later. It doesn't mean that it was recorded illegally, even if they recorded it. As long as at the time they recorded it, they didn't have that intent. So it's interesting. So so they can end up with a legally recorded conversation, and then the crime or tort is actually when they share it then. And then it's okay for media to secretly record for the purpose of information gathering and broadcast. So remember, I looked at when we looked at the first bullet point on this page, we said it's not necessarily okay for the media to legally record people, but once they have that conversation, they can share it. Well, this case says it was okay for the media to secretly record for the purpose of information gathering and broadcast. So what that means is, if whether they're a party to the conversation or not, right? If there's for example, a public meeting where information of public concern is being discussed, and whether they're a party to it or not, they can record it. And then, I mean, that's not necessarily the example that was in that case. I think the case, the matters in this case were more surreptitious than that. And then it's illegal to disclose contents of unauthorized wiretaps. Each playing to someone that hasn't heard it is a cause of action. Threatening to use counts as use as well. So the reason I mention this is because each time that conversation is replayed to a new person, it's a tort. So basically, if you publish the recording on the internet, you pretty much would never have a 2-year time bar, because someone will have always heard it. I mean, listened to it probably within the last 2 years. And then it's okay to disclose contents of conversation while giving testimony. And then domestic conduct is handled by state courts. So it's not in the statute, but the federal courts have said if it's an issue of a domestic dispute, that the federal courts aren't going to make a determination. They're always going to kick it back to the state courts because they feel like domestic disputes are something that the state should handle. So if you're I don't know, if you're recording your whole family because you're having there's a lot of infighting or something, one of the members of your family can't prosecute you under this law. But there's an exception to that where marital disputes would be covered, at least under the civil part of that. So the spouse could sue, but other domestic disputes would be kicked back to state court, whether they're civil or not. And then also, if one of the members of the family hired a PI to record the whole family, though, then it becomes a federal issue again. So let's move on. So where interception took place and not the route the communications took decide the wiretapping law that applies. So this is, it makes sense, but it also means that basically you could route all of your communications through some country other than the United States, and that's where the interception takes place. That's where you record all of your conversations, and it would be illegal. It would be legal as long as when you set that up, you didn't set that up or cause it to be set up from the United States. So you pretty much would have to travel to that country where it's not legal, set up the routing of all of your calls to go through that country and record them there, and then come back to the U.S. But it's an interesting loophole, so that's why I'm sharing it. And then this doesn't apply to silent video surveillance. I'm thinking about, I don't know why I put in there because that's obvious, because we're talking about recording conversations, but I guess if someone could do sign language in the video, that would be an interesting edge case. I don't know if that case law would necessarily apply to that. All right, since we talked about some exceptions to the media, here's how the federal law defines media. So the media reports the truth on events of a social or political nature and not of mere curiosity, investigating completeness in the least invasive way. So at least under federal law, like a lot of the trolls who claim they're reporting the news, right, that they're part of the media, this doesn't apply to them. They're not doing it for a social or a political nature. It definitely is mere curiosity. And then the least invasive way is the opposite of what they're doing. But the federal law says the media is required to do it in the least intrusive way. So they must not unnecessarily intrude on a target of the news in his private capacity. So, and that's something that you definitely see the media doing, right? The media will talk about people all day long, but they're not going to intrude on that person in their private capacity. And that's something that the trolls do all the time. All right, so let's go to, I'm not going to cover all two-party states, obviously, but I'm going to cover California for obvious reasons. It's a two-party state. People call it a two-party state. It's really an all-party state where you need consent of everyone that's in the conversation. So in California and in most states, I think I might have said this before, so wiretapping criminal laws don't apply to participants of the communication. It's wiretapping laws in most states are going to be where you're recording a conversation that you're not a party of. All right, so California says basically that their statute calls for a determination as to whether the circumstances reasonably. Well, I should start out in saying so. Basically, because the federal law sets the grounds for this, the California law just adds additional rules on top. So I'm not going to cover all that. So California has what we just talked about, but additionally, when talking about whether a person has expectation of privacy in public, they say that each case individually calls for a determination as to whether the circumstances reasonably indicate that any party to such communication desires it to be confined to such parties, or whether the circumstances are such that the parties to the communication may reasonably expect that the communication may be overheard or recorded. So basically, there's no hard rule on conversations in public. You might expect a conversation to be overheard in a mall, but it would be reasonable to expect that a news organization wasn't recording it, or that your nemesis Kate and dump truck wasn't recording it. So one interesting thing is you can maintain protection against the dissemination of the recording if you withhold your right to record. So even if you're told that the conversation might be recorded, you should say that you're withholding your right to it being recorded, because then they might still be able to record it, but they can't disseminate it, at least in California. Another interesting thing about this is if you're wearing the wire and then you play dumb by saying, is this conversation confidential or is it being recorded? And then the other person says no, then you're also expected to follow that, even though you posed it as a question because you're trying to be all incognito. So let's stop here and talk about the turtle boy and someone planting a listening device at the booth where they were sitting, or the table or whatever. I'm going to say it's under California law. I know they're in Massachusetts, which is I think is also a two-party state, and it's different law. But under California law, at least, it would be ultimately up to the court to decide if the person had an expectation of privacy. But I would argue if they say, hey, let's get a table over here so we can talk privately, that's an expression of you're wishing for that to be a private conversation. And so someone and if your conversation can't reasonably overheard at other tables, or even if it can be overheard, right? You don't expect that Kate and dump truck are recording it. So I think it could not have legally been recorded. And I know Kate's made videos where she said, "Have no expectation of privacy in public." She's trying to make hard and fast rules where there are no hard and fast rules, and I don't think if there is a recording of that it would be legally recorded based on what Turtle Boy has said. All right, so then let's go back to the next bullet point. So if single party recording is illegal in state, you can't use recording as evidence in state court, but can in federal court. So if you don't have consent to all the parties, your recording was made illegally under California law, but as long as you had one party's consent, you could still use the evidence in federal court. So California law includes one-way recordings. So a one-way recording is this is popular in businesses now trying to circumvent two-way recording laws, where instead of recording both sides of the conversation, they only record their side of the conversation. So, for example, if you're offering telephone customer service at Target, for example, in California, so in order to make sure that you're not violating the laws, you only record your customer services speech and not the speech that's coming into them. Well, California has decided that that's not okay. And I think it kind of makes sense because obviously you can, obviously that conversation was still had with the other party, and you can also obviously get the gist of what was discussed. So, and that's kind of explained to you in this next bullet point. So there's no rule against sharing the contents, so just the first-hand dissemination. So in California, they're basically saying, well, I actually have a quote from case law here. So here's what it says. So while one who imparts private information risks the betrayal of his confidence by the other party, a substantial distinction has been recognized between the second-hand repetition of the contents of a conversation and its simultaneous dissemination to an unannounced second auditor, whether that auditor be a person or a mechanical device. Such secret monitoring denies the speaker an important aspect of privacy of communication, the right to control the nature and extent of the first-hand dissemination of his statements. So, recording your conversation, side of the conversation, without recording the other side of the conversation, I mean, your side of the conversation is still a first-hand recording of the other person's conversation that they should have rights over how it's disseminated, including its recording. So even in California, even if it's recorded legally, it can be used to impeach testimony. So so you could argue, right, that I mean, we're gonna get to it, but in the next bullet point, but if Chile had illegally recorded Todd Lyons' conversation and the court didn't allow him to bring what was recorded in as evidence, he could still use it to impeach testimony. So if Todd says, no, I didn't say that, then Chile could say, well, on the phone you said this. And then so single party permission while collecting evidence of a crime, i.e. harassment, is okay. So it becomes basically a single party state. If the person who's calling you is calling you to commit a crime, including harassment. So this is basically, under California law, at least, what would make it okay for Chile to record the conversation, whether he had Todd's permission or not. And even if Todd withheld his permission. So verbally said, you know, don't record me, please, or don't share this information. Every time Todd Lyons was calling Chile, it was to harass him, it was to troll him. And so under California law, only Chile could record that. So it makes sense, actually, that, you know, Chile most likely can legally record every single one of his conversations, since he always has the expectation that when someone calls him, it's one of his trolls and he needs to collect the evidence. And then it's interesting that from 2019 and in 2021, it was legal to record all of your conversations without the other person's consent. It just wasn't legal to disseminate the recording. That was case. There was a case in 2019 that said that, but then it was overturned in 2021. So again, that would have made, at least from 2019 and 2021, that Chile could record his conversations all day, as long as he didn't disseminate the recording. Right. So then, this is my last line. I'm just going to go over the California jury instructions. There's no federal ones because the federal court system has said that the federal law is so broad. Remember, I was only covering the relevant portions of the federal wiretapping laws that had to do with recording conversations, because they are quite broad, and they admit that they're so broad that no model instruction could possibly capture intent. But the federal court has said that at least minimally intent to record is something that has to be proved, and then intent to use it to commit a crime or tortious act has to be proved, and the intent has to be at the recording, at the time of the recording. And then for their civil awards, you have to prove that it was at least reckless disregard for a legal obligation. But California actually has specific jury instructions for their penal code violation. So the plaintiff claims that the defendant violated their right to privacy. To establish this claim, plaintiff must prove all of the following: that defendant intentionally eavesdropped on or recorded the plaintiff's conversation by using an electronic device, that plaintiff had a reasonable expectation that the conversation was not being overheard or recorded, that defendant did not have the consent of all parties to the conversation to eavesdrop on or record it. Excuse me. So I think, again, if we read these jury instructions given Turtle Boy and Irish Demon in Kate's situation, that the jury would likely convict if the conversation exists, which originally I think they were saying it did exist because they didn't realize that it was illegal. I think first of all they said the Irish Demon recorded it, right? And then once he found out it was a two-party state, he said, no, I didn't record it, someone else did. And the other person can record it because there's no expectation of privacy in public. But there is. All right, so that's all I got for you. Have a good one.